Thank you, ladies and gentlemen. My vice chair is here. I believe we can get started. Thank you, Brian. We're here today, colleagues. We have three bills, 383, 385, and 465. Let's go ahead and get started with our first bill, which is Delegate Smith and says Shetty. I'm sure it's just Delegate Smith presenting. If you have a panel, please bring it up.
Maryland can join several other states in a compact for the cosmetology license. Now, some of you may remember that I have successfully passed a barbering apprenticeship bill through this committee, as well as a cosmetology apprenticeship bill through this committee. And I think with that history, I was working with partners at the Council of State Governments to see how we could enter a compact with other states to ensure that those who have licenses in cosmetology have more mobility. And this is important for two reasons. One, Maryland is a fairly small state that has many borders. It gives you more opportunity to take your skills to neighboring states whilst remaining domiciled in Maryland. Now, also, I'm bringing this bill as part of a priority package through Governor Moore about how we can better support military spouses and families. As some of you may know, I come from a military family. My mother was a military spouse, and there's often challenges around acquiring jobs and keeping them because of the constant moving around. Cosmetology licenses are one of the most dominant licenses in states around the country, and the ability for those who already have those licenses to have portability can enhance their ability to maintain their professional vocation. And also it provides more support for that family where everyone is realizing their professional opportunities and dreams. So I won't repeat a lot of things you're going to hear from my other esteemed colleagues, but I do believe that us entering this compact would be not only in the best interest of those who currently live in the state of Maryland, but for the many military installations we have that will be welcoming families from all over the country. It will provide that support that military spouses and families definitely desire. This bill is coming before you with not only the support of the Moore administration, but also from the Department of Defense that sees this as an imperative. They are big proponents of compacts, and this is their first foray into a compact around a non-medical license. So I thank you for listening, and I hope you do support House Bill 383.
Thank you very much. Next on the panel, please announce yourself.
Thank you so much. My name is Keith Buckout. I'm a research associate for the Council of State Governments. Chair Wilson, Vice Chair Crosby, Delegate Smith, thank you so much for the opportunity to be here today. The Council of State Governments is the nation's only membership organization serving all three branches of state government. And throughout our history, we've promoted multi-state problem solving and supported states in determining their respective futures. To that end, my testimony today is intended to be informational only because of that. In 2020, the Department of Defense entered into a cooperative agreement with my organization, the Council of State Governments, to fund the development of new interstate compacts for occupational licensure. And the cosmetology profession was selected through a competitive request for proposal process. The purpose of the compact is to create an additional optional alternative pathway to multi-state practice by allowing cosmetologists whose license is in good standing to apply for a multi-state license in their home state. Under this mutual recognition model of interstate practice, compact member states agree to recognize the multi-state licenses issued by the home state as authorizing practice of cosmetology within their jurisdiction. The intent is that the multi-state license functions like a driver's license. The home state issues the license, and then it authorizes practice in any other state that is a member of the compact. To be eligible to join the cosmetology licensure compact, a state must license and regulate cosmetology, require that applicants for licensure pass a cosmetology competency examination, require that applicants for licensure satisfy educational or training requirements in cosmetology, and implement and maintain procedures for considering one or more of the following categories of information from applicants: either a criminal history application question, a license disciplinary application question, or a background check. And as Maryland is a state with several major military installations, it's important to note that there is a provision allowing active military members or their spouses additional licensure mobility to ensure the compact meets the mobile military needs. Thank you for your time, and I'd be happy to answer any questions the committee may have.
Thank you, and I would remind everyone listening and the people testifying that this bill is not opposed. So I think you have to do a lot of selling. Sometimes the shorter the better. Being concise is not a problem in this committee. Thank you very much.
Great. Chair Wilson, Vice Chair Crosby, thanks so much for having me. My name is Tony Woods. I'm the Secretary of the Department of Veterans Affairs, and I of course ask for a favorable report on Maryland joining the cosmetology licensure compact. I'll keep my remarks very brief. Folks were kind of curious why the Maryland Department of Veterans Affairs cares about cosmetology, and I can tell you because our mission is to support veterans, transitioning service members, and their families. And we think that this bill goes a long way in supporting thriving military families and ensuring that spouses who practice cosmetology are also able to have their licenses transferred seamlessly to our state. And so we appreciate Delegate Smith's leadership on this. We hope that we can see several other areas of our state entering into multi-state compacts to ease military transitions. So thank you so much, and I appreciate your time.
All right, I will keep mine very brief. Chairman and members of the committee, I'm here to encourage you to support House Bill 383, which it sounds like you already are in favor of. So I'm delighted. My name is Leslie Rosti. I'm from the FBIC, the Future of the Beauty Industry Coalition. We are the industry sponsor for this bill, working hand in hand with the CSG. We represent businesses that work across many state lines. Think of things like Great Clips, Sport Clips, Ulta that you might see in all 50 states. And you can probably understand for a small business the benefit of being able to draw from a neighboring state or being able to send an employee to a neighboring state should you have that need. So we would strongly encourage you to support House Bill 383. Thank you.
Seeing no questions, none. I think this panel can be excused. Corey Harper. John Dove. Ma'am, you can go ahead. Ms. Harper, you can go ahead and start when you're ready.
Okay, thank you, committee members and Delegate Smith. My name is Corey Harper. I'm your constituent. I'm a licensed hairstylist of 25 years, and I'm here to urge you to support the House Bill 383. For the last 25 years, I've had a great career path in the beauty industry. I attended cosmetology school in Florida, and I was able to start working in a salon after I completed my education. I was not yet licensed in Florida when my family had to move to Maryland. It was a difficult and cumbersome process to become licensed in Maryland. It was time consuming, and it delayed my ability to earn a living in the industry that I wanted to be in. I've worked with cosmetology students for years, and I'm currently an operations manager for an international hair care brand. So I've listened to hundreds of students and stylists, and I've heard their concerns, their frustrations, and I've been a part of their burden in relocating and pursuing their careers across state lines. I currently support stylists and salon owners in Maryland, DC, Virginia, West Virginia, and North Carolina. Many of the salon owners have salons across state borders, and their stylists are unable to work just a few miles away in one of their sister salons. It just doesn't make sense. So thank you for your consideration of the House Bill 383. And please remember that hours may vary from state to state, but all states require a consistent and comprehensive safety and sanitation curriculum. That is always the state's #1 priority. So states already allow reciprocity, but it is burdensome and it doesn't acknowledge the situation of multi-state careers. So this compact would provide incredible flexibility and career growth for cosmetology students and licensed stylists. So let's remove the barriers for licensed stylists so they can continuously earn and grow in this amazing industry. Thank you.
Good afternoon. For the record, my name is John Dove. Excuse me. I'm the Commissioner of Division of Occupational Professional Licensing in the Maryland Department of Labor. Online with me is our Executive Director for Cosmetology, Nicole Fletcher. She's here to answer any questions should you have them. I'd like to thank Chair Wilson and the committee members for allowing us to express our support for SB 383. I will keep this very brief. The main thing I want to just reiterate without being redundant is that the safety aspects of this program will be maintained. Under the terms of the compact, the Maryland Board retains the ability to revoke a licensee's authorization to practice in Maryland should a violation of the law or regulation occur. Cosmetologists who desire to open their own salon will still also be required to obtain business licensing and all relevant health and safety inspections before being permitted to operate in Maryland. This allows the board to continue to protect the health, safety, and welfare of Maryland consumers while providing the benefit of licensed mobility to beauty professionals across the country. Again, thank you for your time, and we ask for this committee's favorable report on the Cosmetology Compact. Thank you.
They just want it recorded, which makes sense. On page 8, line 21, it says the reissuance of a multi-state license by a new home state. That's the subject matter starting in line 21, page 8. And then it goes on, a licensee may hold a multi-state license issued by their home state in only one member state and at any given time. If a licensee changes their home state by moving between two member states, they shall immediately apply for the reissuance of their multi-state license in the new home state and then pay the applicable fees and notify the prior state that they moved. I'm just trying to figure out what's the benefit of this if you're still paying a fee every time you move.
It may just be they want that state to be their home state. So if somebody's in Maryland and they know that Florida's going to be their permanent home when they finally get there, from here on out, Florida's going to be where I'm going to live at. They may just want to change their home state to Florida. I mean, that would be the,
But I guess
they could have kept it in Maryland if they wanted to, but
that's not what I asked.
Okay.
I appreciate that and I get it. But what I'm asking is the theory of the bill behind it, as I understand it, is to make it easier and less expensive for people in the cosmetology industry. This line item does not do that at all. In fact, it completely obviates the bill
maybe
by charging a fee no matter where you
maybe I'm
go.
misunderstanding.
So-
Do you mind if I answer?
Oh, please.
Okay, so the intent of that provision in the bill is to have or if someone were to move between states. So when a licensee has a multi-state license, they carry authorizations to practice in every other state. But the license still is issued by the home state. So if we were to compare it to like a driver's license model, you get a certain number of days when you change your residence, when you're in a new state, to update your driver's license information. The intent of that provision is to work exactly the same way. So
But
if
you
you
still have
actually,
to pay the fee.
yes, you do have
Okay.
to pay a fee
Thank
for your state to issue you a
Thank you.
license. Yes.
Thank you.
Delegate Sheen.
Thank you, Mr. Chair. I actually, since now you came back, I'm gonna ask the question of Mr. Buckout. So this is a brand new compact you are proposing. We are proposing, right?
Yes.
Okay. Do you know how many of our neighboring states are also interested in this? Are they also trying to advance similar legislation?
Yes, ma'am. There's currently active legislation in Pennsylvania, Virginia. We are anticipating a bill being filed in Delaware, although we can't speak to that yet. But we're also hopeful for a bill filing in West Virginia. At the moment, I think that's the neighboring states that are Maryland. I'm sorry, I'm trying to think of the map.
So this will be the first in the country for this cosmetology compact?
Yes. So the draft of the compact, the model legislation, was finalized in November of 2022, and then it was released to states for the 2023 legislative sessions. And so this is the second legislative cycle that it's been available to states. So this would be, yes, new. It does require 7 states before the commission that administers the compact can be established. And then multi-state licenses could be issued. But yes, this is a new compact.
Okay. All right. Thank you.
Thank you.
Seeing no further questions. Okay, guys, I believe that's everyone. Okay, thank you. We now have virtual Nicole Fletcher. Go ahead, ma'am.
Good afternoon, committee. Thank you. My name is Nicole Fletcher. As Commissioner Dove mentioned, I am the Executive Director of the Maryland Board of Cosmetologists, of course, favorable for House Bill 383. I'd like you to consider it, of course, and just here if you have any questions. Thank you.
Phenomenal testimony, ma'am. We really appreciate that. And I mean that seriously. Next person we have is Christopher Arnold.
Chairman, the Department of Defense is grateful for the opportunity to support the policy changes reflected in House Bill 383. We thank Delegate Smith for her leadership in introducing this important initiative. I'm Christopher Arnold, Mid-Atlantic Region Liaison at the United States Department of Defense State Liaison Office. As you heard, the drafting of the compact was funded by DoD through our cooperative agreement with CSG. Congress has required us to produce 10 such compacts, which are significant for the military community, in that along with active duty military spouses receiving the benefit of compacts, active duty members, members of the reserve component spouses, transitioning service members, and other veterans benefit from the mobility provided through compacts, as Marylanders serving around the country will have their multi-state license recognized when transitioning in and out of other states. Federal law requires the secretaries of the military departments to consider a state's membership in interstate licensing compacts when evaluating basing decisions. A consistent framework ensures optimal employment conditions for our service members and their families. As always, as liaison to the Mid-Atlantic, I stand ready to answer any questions you may have.
Seeing no questions for this panel, I believe that concludes this bill. Thank you very much again, and Delegate Smith for this very edgy bill. Clearly, it's not a lot of opposition, but again, thank you guys. Moving on to Delegate Long, House Bill 385. If you have a panel delegate, please bring them up with you.
Yes.
Thank you so much, Mr. Chair. Good afternoon, Chair Wilson, Vice Chair Crosby, and members of the Economic Matters Committee. I'm Delegate Jeffrey Long Jr. for the record, and this is my first time before this great committee. Today, we're hearing HB 385, which is the Pay Stub Transparency Act, also known as Wage Payment and Collection, Pay Stubs and Pay Statements, Required Information. This bill would require that workers' pay stubs show enough information for workers to understand how their pay was calculated, helping eliminate wage theft and leveling the playing field for law-abiding businesses. Most employers follow the law, but wage theft remains a major problem for many thousands of Marylanders, low-wage workers. Unfortunately, some bad actors cheat employees out of their earned wages by masking their illegal conduct on pay stubs. For example, an employer might lump together all compensation on a pay stub, making it nearly impossible for an employee to figure out their wage rate or see whether they are paid correctly for overtime work. Right now, presently, Maryland law only requires that pay stubs include, number one, gross earnings, and two, deductions. That does not give workers enough information to determine if they've been paid correctly. Moreover, the law does not provide any remedy if the employer fails to provide even that very basic information. The bill has two parts. First, it sets out what must go on pay stubs, including the dates of work covered by the pay period, number of hours worked, rate of pay, and the amount and purpose of all deductions. The vast majority of law-abiding employers already provide this information on pay stubs. Second, it allows workers or the Attorney General to file a complaint in court if the pay stubs do not meet the requirements, and the workers would receive $100 per work week in which there's a violation, up to a maximum of $5,000, so no one will be getting rich off of these violations. The maximum of $5,000 makes it clear, as stated, that no one is getting rich pursuing violations of this bill. I want to also add that HB 385 is a simple solution to help ensure workers get paid what they're owed. Many other states, including California, Massachusetts, Minnesota, New York, Pennsylvania, Texas, Virginia, and Washington already have pay stub requirements that are much more robust than what Maryland currently requires. We're behind the curve, and HB 385 will catch us up. I'm glad to have a great panel here. Commissioner Devke Verk and other individuals we'll be working with as stakeholders. We've worked together to get some amendments in good position. And so again, I asked this committee for a favorable report. We're here to answer any questions that you may have. Thank you.
Good afternoon, Mr. Chair, Mr. Vice Chair, and members of the committee. My name is David Rodwin, and I lead the Workplace Justice Project at the Public Justice Center, and we're very grateful to Delegate Long for bringing this very important bill. Workers can't get ahead if they don't have the information to understand if they've been paid correctly. It's very often the case that workers who have been underpaid cannot even figure out how much they were underpaid or how they were underpaid because they get either no pay stub at all, just like in our testimony here, a check that says $1,000 for in the for field work, or they're given a pay stub with grossly inadequate information. As the delegate mentioned, under current Maryland law, the only things that are required to go on pay stubs are gross wages and deductions. That's not enough. Pay dates aren't on there. Pay rates aren't on there. Overtime pay isn't on there. And even if gross wages and deductions, those very limited requirements, are not provided on a pay stub, Maryland law doesn't allow a worker to do anything about it, and it doesn't allow the Maryland Department of Labor to do anything about it either. So it might as well not even be a requirement in Maryland law. So this bill, as the delegate mentioned, is quite simple. It just puts the most basic information, requires that most basic information go on workers' pay stubs, and then it gives workers a remedy to enforce that law if there's a violation. I also want to note there may be some confusion as to who is covered by this bill. It does not apply to government. It doesn't apply to Maryland state employees, local employees, county employees. The Maryland Wage Payment and Collection Law does not apply to government employers. So with that, we'll ask for a favorable report on this important bill. Thank you.
Come on. Thank you, Chair Wilson, Vice Chair Cosby, for the opportunity to speak favorably with amendments on HB 385. My name is Devke Verk. I'm the Commissioner of the Division of Labor and Industry for the Maryland Department of Labor. Among other things, my division is responsible for enforcing the wage and hour laws of the state of Maryland. Try to be brief. The bill in front of you would assist our enforcement efforts by making them more efficient. When people understand what the components of their pay are, they can detect problems in their pay more quickly, and those issues can get resolved more quickly, both with the employer in the first instance, and if necessary, by our department in the second instance. So it would assist and make more efficient our enforcement efforts. We do have two suggested amendments to the bill, which we have discussed with Delegate Long. The first of these is, as it's currently drafted, there is no administrative enforcement mechanism within the Maryland Department of Labor. And we would ask that there be an administrative process that is permitted in addition to the private right of action. That would allow our wage and hour staff to receive complaints and do something about them and process them and make that process certainly more efficient than a civil right of action. Our second amendment is in what's currently section 3-507.1, which is the wage order provision of the Wage Payment and Collection Law. That is a provision that allows essentially a separate process for small claims. So claims of wages of less than $5,000. There's a purely administrative process that is permitted, obviously with due process to the employer in a contested case, but it often allows employees to get their wages paid that are owed to them more quickly. And we would ask that there be a provision in that for treble damages to be imposed upon employers, which is currently only available through a civil right of action. Thank you. I would be to answer any questions that you might have.
Good afternoon, and thank you, Chairman Wilson and members of the committee. My name is Roxy Mejia. I am here on behalf of the International Union of Painters and Allied Trades, District Council 51. We represent over 1,500 construction workers in the Finishing Trades Institute in Maryland, Virginia, and the District of Columbia. I'm here today to testify in support of HB 385, pay stub transparency. Wage theft is a very significant problem for our members and all workers in the construction industry. It further affects women in the construction industry who look like me. Too often, we receive pay statements that do not show our pay rates, our hours of work, deductions, or even the dates of the pay period. Unlike other states, Maryland does not create any way for workers to correct this problem. The lack of information on pay stubs is a way to hide wage theft. Without basic information about rates, hours, and dates, there's no way for a worker to check to make sure that they are being paid correctly. Many of our members continue to face this problem. The resulting wage theft makes it harder for them to be able to provide middle-class and sustainable wage life for themselves and for their family. This is a simple bill and common sense way to fix the problem of employers hiding wage theft with confusing pay statements. Most employers already do this basic information on pay statements. It is not too much to ask for all employers to provide the same information. Therefore, I'm here to ask support in a favorable report for HB 385. Thank you for your time.
Thank you very much. I guess my question goes to Madam Secretary. And I see we have at least 2, 3, 4. We have a lot of other questions, but start with, am I to understand right now that there's no enforcement mechanism within your department for this, correct?
That is correct.
Is there a current private right of action?
There is not.
Okay. Are you, does this bill request to require a private right of action?
Yes, as it is drafted, that is the enforcement mechanism. Our amendment would add an administrative process as an option.
And I asked that for a very specific reason. So you do believe that you can handle and deal with these complaints, correct?
Yes, when we get them now, we just simply don't have anything that we can do with them.
Correct. So a private right of action may not be necessary because it sounds like you can remedy this within your division, correct?
Not under current law, sir.
No. I'm talking about this bill with your amendments would allow, if we took out the private right of action, they could still basically be able to report and get the justice that they deserve, correct?
There would be an administrative process. I mean, certainly a private right of action permits an additional option for individuals to hire their own lawyers.
I'll say a different way. A lot of times when people come in here, they do a private right of action, or a lot of the divisions come in and say, well, the reason they're doing a private right of action is because we don't have the resources to enforce this. But you're saying you do have the resources. In fact, you're asking for the ability to also be able to enforce it, correct?
We are asking for the ability to enforce.
Thank you very much.
Oh, no. Thank you, Mr. Chairman. My questions are really more clarifying. So I was going through the opposed, and you have one from the Maryland Association of Counties. And they talked about some vague language in the bill about how to describe the calculations or whatever. But then I heard in the testimony later that government agencies are not part of this. So was that a change, or is that did they misunderstand that they are not part of this initially? What can you clarify their concerns?
Thank you, Delegate Queen, for that question. 2 things. One is that some large payroll processing companies reached out. They were fine with the bill. They said they could do it. They had, I think one had one very minor technical suggestion that doesn't go to the substance of anything. Second, just to read from the Maryland Department of Labor's website, it says federal, state, and local governments are exempt from the provisions of the wage payment and collection law. This bill is situated within the wage payment and collection law, which already doesn't apply to any unit of state government. So counties, cities, the state itself, nothing to worry about with this bill. It does not apply to them.
So I kind of answered my question. Do you think that this bill should apply? I mean, we've got a very large public employee base in this county, significant, federal, state, local, significant. I mean, do you think this bill should apply to them other than the reason you just gave?
Speaking for myself personally, Delegate Pippi, I'm not worried about units of state government, giving workers a check that just says $1,000 for work. They've got their own payroll systems. There's already in some cases a fair amount of oversight there. Certainly, I would trust the comptroller's office to ensure that workers receive adequate information on their pay stubs. So certainly, we want all workers, including government employees, to be paid correctly and to have the information to understand that. But I have never seen a state employee complain to the Public Justice Center about not receiving information on their pay stub to understand why they were paid what they were paid.
So, and I'll be quick. So have you verified that all the state, local, and federal governments that do business in Maryland have provided the information that you've put forth in this bill?
I have not verified all of them, but I have seen what pay stubs look like for government employees, and they include this information.
Would a public individual be able to have a private right of action against a government unit if they didn't have this information? Do you know that answer?
Well, the wage payment and collection law, because it doesn't apply to units of government, it has no effect on them one way or the other. So they already can sue under the Fair Labor Standards Act if they are underpaid under that federal law. So there is a federal private right of action under that law, yes.
So the last question is quick. So the third party provider, is that, this just says employer. So in the case where a third party provider, like maybe one of the ones you mentioned, a very large one, for whatever reason does not provide that information, maybe even after been instructed to do so, is the employee still suing the employer, and is your department still going after the employer, or are you going after the third party provider?
It's the employer's responsibility to ensure that it provides the information. The employer can choose to sort of outsource that responsibility to a third-party payroll processing company. All the large ones are already providing this information. There's no issue with it whatsoever because all this stuff is all the common sense stuff that 95% of workers get on their pay stubs anyway. And certainly if there's any minor thing that needs to be added as a result of this bill, I'm sure the payroll processing companies will take care of that for employers. So I think it's extraordinarily unlikely that any payroll processing company wouldn't provide anything that this bill requires.
Thank you, Mr. Chairman.
Just include them in anyway, just in case you missed something. Why not include federal, state? I mean, state and local government.
Thank you, Delegate. Do I understand correctly? Why isn't it expressly excluded?
Why wouldn't we do that? Because if it does happen in the state, you're looking for an employer, a business employer, to pay a premium for that if they cause that problem. You're looking to the damages and what have you. Why not put it to the state when it does happen if the state is failing some?
I'm sorry for asking again. So why not? Why doesn't the bill just say expressly this does not apply to state and local governments? Is that the question?
Why wouldn't you include them? Why wouldn't you include them?
Why wouldn't we include it?
Yeah, why wouldn't they be in the bill?
I can't say it's super fun to go up against MACO in a.
Well, I'm not looking at MACO. I'm saying is the state infallible? The state's never had a complaint like this?
I've worked at the Public Justice Center for almost 9 years now. I've never gotten a complaint from a county employee or state employee that their pay stubs didn't show adequate information on them. For state employees, the comptroller's office takes care of it. County employers typically work with a third party, either a third party payroll processing company, or they handle it in-house, and it's all done with a set software.
Okay, for the commissioner, did you mention something that when the chairman was asking a question, you don't have a mechanism to handle this now, you said?
That's correct. I mean, we get complaints from people who don't have adequate information on their pay stub, sir, but we are unable to actually provide them with any redress.
What do we do for it? We just say no? We let them go, or do we actually do something?
Well, we sometimes, with the employee's permission, reach out to the employer and advise them as to what their obligations are under the act.
So in today's world, if I'm not getting paid, if I'm just getting this information, I have nowhere to turn in the state to help.
That's correct.
Department of Labor.
That's
And-
correct.
And you feel it's necessary to put triple damages?
No,
Okay.
sorry, I went a little long, so I didn't fully explain the Second Amendment. The Second Amendment is actually on the wage order provision, which is 3507.1, which currently allows a purely administrative process for small wage claims, currently under $5,000. And the only recovery that an individual can get under that wage order provision is exactly what they earned to begin with. However, if they file a civil lawsuit, the judge may award up to 3 times the amount of wages that were owed, so long as those wages are not in bona fide dispute, meaning there's no dispute that wages were owed and how much was owed.
Okay,
What I'm asking for, I'm sorry, is to allow for that remedy under the administrative small claims process as well, so that people don't have to file a civil lawsuit in order to get the money that is owed them.
Okay, how many of these complaints do you get a year, do you think?
Complaints about, I'm
About
sorry,
the information, not having.
about the lack of information. Since we really don't have an enforcement mechanism, we don't keep numbers on it, but my understanding is that it's a fair amount of our claims. We get approximately 1,000 claims a year, and a significant proportion of those, can't give you an exact number.
50% of those?
I don't know.
Okay, thank you very much.
Thank you.
Thank you, Mr. Chairman. To the commissioner, just want to clarify, because I actually don't know the full answer to this. What is currently required of a private employer to put on the pay stub? What is the current requirement?
I believe that it is the gross amount of pay and the deductions.
So, and the deductions would be that are required to be on the pay stub, all of them, whatever they may be? Or not necessarily, though.
I think the notion is that if you are deducting, says for each pay period, a statement of the gross earnings of the employee and deductions from those gross earnings. That's all it says.
So would you advocate for itemizing those deductions like state withholding tax and federal withholding tax? I mean, you would think that most employers would be doing that now, right?
Yes.
Okay.
You would think so.
How about the family program, once that's implemented?
Yes.
Since you guys are implementing that.
Yes. I mean, if there are deductions from gross earnings,
because that could be significant.
well, all deductions from pay are at least potentially significant. Health insurance, right?
The first
et
three that
cetera.
I mentioned are state, federal, and family, which is yet another state program. That money is going to the state. We're talking about wage theft, and I'm just talking about how much money is coming from the paycheck to the state and to the feds.
Yeah, people
which
should see that.
Sounds a little bit like wage theft. So the other one is the Maryland Savings Plan, because that's the newest one that's being implemented. That's the savings plan that the state is managing and trying to impose on the small businesses and folks to deduct, right? You're familiar with that one?
I'm actually not familiar with it. I apologize.
It's worth being familiar with because the department's probably going to get a lot of questions when people have deductions from their paycheck because they were signed up for this program that's being administered by the state, but the small businesses have to, of course, do the back office administration for paychecks. And that seems like that would be worthwhile putting on the pay stub as well.
Yes,
How about union dues? Is that required to be put on the pay stub?
it should be.
Okay, but it's not required though.
It's not, I mean, right now, all it says, sir, is exactly the words that I read to you.
Okay.
Deductions from gross earnings.
Okay. Because I bring all this up because I think that it's reasonable for an employee in many cases to, especially a new employee, someone that hasn't ever gotten a paycheck or changed jobs, to suddenly get a paycheck with a pay stub that doesn't have these itemizations and can't believe how much money is being confiscated by the state and the feds, which could be construed as wage theft when in fact it's not really the employer that's stealing it, it's the government.
We still know this time.
Yeah, at least they would know, right? So thank you.
I appreciate that loaded question. I want you guys to know that we still have quite a few witnesses on the next wonderful hearing, so save some of that energy. I believe we have a vice chair. We have a question for my vice chair.
Thank you, Mr. Chair. And quickly for the sponsor, it's a moot point, but knowing that the state wants to lead, there's no issue including state and counties into the bill, correct?
I'm amenable.
Thank you.
Mr. Chair, if I can also add to referencing the private right of action, you'll find that on the last page of the amendment that I did not get back from bill drafting until this morning. I'll just read very briefly. This subsection shall be based on hourly rates not to exceed the rates established by the local rules of the U.S. District Court for the District of Maryland. So would put a cap on rates referencing that private right of action.
It's the rates set out in Appendix B to the local rules. It depends on years of experience. Under those local rules, my rate I graduated law school in 2012, it's $275 an hour. It's far less than what I think the private market typically commands. And far less than I think a lot of plaintiffs' attorneys would be satisfied with, candidly.
I'm pretty sure by now people are aware of my lack of appetite for private right of action, which is why I was talking to Madam Secretary, because it sounds like this might be a moot point since they do want to step in and be able to enforce. Don't know if that was a question, but.
No, there wasn't. I just, a correction for the record. I'm not Madam Secretary. That's my boss.
I apologize.
Secretary Wu.
What is your position?
It's Commissioner of Labor.
Commissioner, yeah, I'm sorry. I would like to say it's been a long day, but it hasn't. I'm just.
Not yet.
I think it's going to be a long day. So I think therein lies my exhaustion already. It's pre-exhaustion. I don't see any other questions for this panel. Jeff, is this all you have? Did you have?
Yes, sir, Mr. Chair. Thank you so much.
Thank you very much. Now we're calling William Steinwedel, Milton Corrado, Mike, oh nope, that's all. And then we have one virtual witness after that. So again, go ahead and state your name, sir.
Hi, my name is William Steinwedel. I'm a supervising attorney with the Maryland Legal Aid Bureau, and I'm testifying in support of House Bill 385. I thank the committee and Delegate Long for inviting me to speak on this bill. So I've been handling wage claims for over a decade, both at Legal Aid and in my previous career. And I think this bill will go a long way to resolving a lot of the issues that exist. For one example, I once represented a person who worked at a cleaning shop, and it was 7 different cleaning shops, and they all had different LLCs. So they weren't sure exactly who owned them and who was supposed to get paid, who they were supposed to get paid from. So I think the information that it would be allowed in this bill would go a long way to resolving these issues. In addition, there is a great issue in this state of people who work and who have limited English proficiency, and that is very typical in jobs where very limited information is provided for the wages that in these jobs that a lot of immigrants have, and this does cause a lot of problems, and it does cause a lot of abuse. Finally, in the hospitality industry, there is some issues of because as all of the members of the committee are aware, you can get paid less than minimum wage if you work in the restaurant and hospitality industry. However, you must receive all of your tips. There is an issue sometimes that employers take the tips, especially the ones that are cash tips. And I think having to disclose all of the income on the pay stub will limit this a great deal. Now, it may cause some more tax liabilities, but it also will make sure that everyone is getting paid their full share. Thank you, and I can answer any questions you may have.
Seeing no questions. Thank you very much, sir. I believe we have one on virtual. Alice Jacobson. Brief indulgence. Ma'am, if you can hear me, we see that you're in the call. We need to turn your video on.
It's telling me that I can't turn it on, that it's at your end. There we go. Hello, I'm Alice Jacobson. I'm the Director of Government Relations for Payroll Org, representing payroll professionals who are directly responsible for preparing and distributing pay statements to employees. We agree with bill sponsors that transparency is very important for employees to understand their pay and legal withholding. We also want to make sure that employers are able to be compliant with state laws, and this requires some consistency in language to ensure that terms make sense. So we're recommending 2 language changes. First, instead of referring to a requirement to include dates of work covered, please consider beginning and ending dates of the pay period. This language is clearer to employees, makes sense for payroll professionals, and shows more accurately federal and state taxes, child support withholding, healthcare insurance, and retirement plan payments. Second, requiring a description of the information used by the employer to calculate the employee's gross and net pay is redundant with requirements to include dates of work covered by the pay period, hours worked, rates of pay, and the number of pieces completed. In addition, using the term net pay implies that employers must explain each tax and deduction listed on the pay statement. Payroll professionals and their employers are not permitted to serve as tax practitioners for employees, and nor can they serve as wealth managers. So we ask that you make another change there, which is to say that the information used by the employer to calculate the employee's gross pay. I've submitted a letter to all of you. Thank you very much for your time. I appreciate it.
Being no questions, thank you very much, ma'am. Now we're going to move on to the unfavorables. We have Mike O'Halloran, Sarah Price, Kirk McCauley. I believe that's all.
Good afternoon, Mr. Chairman. I'll just go ahead and get started as the others come up. For the record, my name is Mike O'Halloran here today, representing NFIB in Maryland in respectful opposition to House Bill 385. I'll focus in on 3 points. Number one is, and as discussed in prior panels, there's a lot of vagueness to the bill as it's drafted, specifically lines 17 through 19, Roman numeral 6 and 7. Roman numeral 6, the amount and purpose of all deductions. I think, respectfully speaking, since you all were involved in the family medical leave insurance program debate, I bet you an employer could have a lot of fun with describing family medical leave insurance deductions. As far as Roman numeral 7, description of the information used by the employer to calculate the employee's gross and net pay seems rather redundant after Roman numeral 5. As far as current law stands, I'd like to point out, and I draw your attention to the fiscal note, there is already a robust enforcement and penalty provisions for the state's wage payment and collection law. And as far as, last year's complaints, it's interesting, the department, it seems the way they calculated, there's a difference. The complaints are received in a calendar year, but the way they dole out the dispositions is done in a fiscal year. But that being said, last year there were, I think it was around 900 or so complaints on the wage payment and collection law. Of those, less than 5% were referred to the Attorney General's office for action. So that's not to say that those complaints were unfounded. In fact, that some of those complaints weren't, handled, negotiated out with the employer. But I think the issue I'm trying to make is, is this an actual problem? And I'll leave my my other issue to the rest of the panel. Appreciate your time.
Chair Wilson, Vice Chair Crosby, members of the Economic Matters Committee. My name is Kirk McCauley. My employer is WMDA Car. We represent service stations, convenience stores, and automotive repair shops in the state of Maryland. Mike touched on the one issue with the redundance on the description of the paycheck. It's all there anyway. It's just going back over it. I also have a members as far as having the business owner's name and telephone number and address on it. I think it's all right to put the business address on it and the name of the owner and the business phone number, but putting out an owner's home address and phone and everything, I don't think that's really good for, we've had a lot of weird things happen the last couple of years with disgruntled employees and so forth. So I don't think that's necessary. And the penalties on the bill. It's up to the employer to prove that the burden's on him to prove that he didn't know it. He didn't knowingly have a false pay stub with especially with a third party vendor doing the work. So there's a lot of open area there that $5,000 up to $5,000 if an employee just happened to see the mistake at the end of the year and he's got 52 weeks of back pay, he can get $5,000 if he just happens to see one mistake that really didn't make a difference, but he found it. So I just think it's excessive. But other than that, we're all right with the bill as far as what it requires. Thank you.
Thank you. Good afternoon, Mr. Chair and honorable members of the committee. My name is Sarah Price, and I'm here on behalf of the Maryland Retailers Alliance. My issues have basically already been stated, not only by Ms. Jacobson and the rest of the panel, but Mr. Chair himself with his line of questioning regarding private right of action and whether it is even necessary if the department has other measures to address these issues. So frankly, I would say me too.
Excellent presentation, ma'am. I guess I have a question or two for the panel. I'm trying to wrap my mind around why it's a bad thing to have the I mean, if you're saying certain information, because I don't believe by the bill that it's personal home address. I do believe it's employer, like where the employee, where the employer, where the business is, as well as that number. So I don't see that as intrusive. But I guess, you know, especially we took out the private right of action. I'm just missing it. I understand, Kurt, you said that, well, sometimes these things are mistakes. And I guess, like I said, you're talking about good faith, bad faith. And if you're using a third party, I believe that, you know, you can obviously bring these individuals in. Obviously, I would assume that they would be responsible for their mistakes. I just think, I'm just trying to wrap my mind around why this is a bad idea. And I understand if you don't like all all of the lines in the bill, but it doesn't sound like they're trying to trick employers and catch them slipping. I think, you know, again, you talk about trouble damages. I don't believe that that's required. And I believe that would be a case by case basis. And if not, we can make it so. Are we just asking you guys to put too much information on a pay stub? Is that the basis of the problem? Mr. O'Halloran, is that the problem?
I don't think it is, Chair Wilson. It's not everything that's on the paycheck, except for the explanation of what you just did. We're okay with. We think you should be getting the gross pay, net pay, and tax deductions and so forth.
And they're saying, but right now that's not required, right? It's
no, that's not required now, but we're okay with that. But what we were talking about was what we're not okay with is page 2, line 18 and 19, a description of information used by the employer to calculate employees' gross and net pay. We've already put gross and net pay down there. It's calculated by the hours that are there too.
So is that problematic? Is it too much ink? I don't understand.
Well, I don't understand what they want.
So if
okay, that's what I'm saying. If it's not clear, go ahead, ma'am.
I think some of the confusion is around whether those lines are even necessary. It's asking for a description of how did you calculate it? it almost sounds like a school math problem. Do the subtraction and then tell me how you got it. Well, I got my answer by doing the subtraction. If the bill is already requiring your gross pay and your deductions to be itemized out, we got the net pay by doing the math and subtracting, making the deductions from the gross pay. So I think it's just, from the business community, it's a question of, is there more that is expected there, or is just, here are the numbers and the math is done? Is that enough?
I definitely understand what you're saying. It sounds like it's redundant. Obviously, that can be dealt with. I just want to go back to the basis of this bill. You know, I've heard, you know, I don't want to call it nitpicking, you guys have identified small issues that we can resolve. But it sounds like the basis of this bill is that that it's required that with specificity that these things be on there. And if people aren't doing it, they can be held to a standard. That just sounds like what, again, we have subcommittees, we have an entire committee to tighten it up, to make sure that we're not, you know, stepping on things, we're not being redundant, that we're not making things too difficult or setting our employers up for failure. And you know that that's not what I do at all. But I just don't understand why this is a bad bill, because it sounds like you guys almost are favorable with amendments. I understand.
There's no option for neutral with amendments, which that's
Good point.
sometimes that's where we stand.
And to pick up on that, Ms. Price is absolutely right. You know, and I also, you know, in addition to, you know, fine tuning it, Mr. Chairman, I think that's taken in stride. I mean, I think you're not going to get an argument from, you know, most of this bill is reasonable. In fact, I shared that sentiment with the bill sponsor. You know, I would caution, believe it or not, there are some small employers out there that have 1, 2, 3 employees that are literally just handwriting the checks, keeping the ledgers. So, you know, and I don't have the answer right here, right now, but, you know, it's something to keep in mind as whether it's subcommittee, full committee goes about this. There are those employers out there, and certainly, and my guess is, you know, when this law was originally created, that was more prevalent. Which is reflected in the current law. So it's how you thread that needle, you know, I'm happy to discuss.
And again, before I go into delegate charcuterie, and I say all this for a reason, guys, and I'm not going to say it too many more times. I don't have to ask a question. When people say no, I worry sometimes you just take yourself off the table when it comes to negotiation, because if you're just going to come up and oppose things and it looks like it's going to go forward, they're not going to come back to you to talk to you because you said no. And I was trying to give you guys an opportunity, especially if something sounds common sense. And I know you all have a job to do and you do it well, which is why I'm giving you this opportunity. I'm not trying to get you to adopt any stance. I'm just trying to let you understand when you say no, and I'm not talking about the unfavorable. I get that. There's only a few ways to lay it out. I'm talking about with your testimony and your, you know, that I don't want you to take yourself off the table. Your voices are important. And stuff like this, it seems like an important thing that we can do. It's fairly simple. I want your voices to be heard, even if this bill moves forward. Okay. So I just know y'all are in the habit of saying no a lot. And every now and then, maybe, you know, or, you know, no, but, you know, give us a no, but if we're going to do it, you know, some assistance would be nice. Delegate Charcuterie.
You actually asked several of the questions I was going to ask. As always, we're on the same wavelength, Mr. Chair, you and me. You and me. So I just want to follow up with one sort of smaller piece. I was confused about the concern about the address. The chair sort of addressed that. I mean, there's a registered business address that's public information, correct?
I assume there is.
Like if you're
I
a business
haven't
and you're
seen
paying
what
taxes.
it is, whether it's the owner's name or the owner's local address where he lives.
Okay.
Does he file that business in his all I'm saying is
It's
the
my
business
understanding.
address should be on there, but his personal address should not be.
Yeah, I don't think this means that this is the name registered with the state, the address and telephone number. So maybe it's just a clarification. I don't think this is
I think
asking.
you're right.
Yeah,
People's
sorry,
phone
not to
address.
if you're right, that's fine. I just
Okay, okay.
you know, I
'Cause that's-
know you wouldn't want your address put out there for, you know.
It's kind of out there actually, so that's another issue. So my second question, I think, Mike, this is for you. Even if it's a smaller employer, right, and you're handwriting it, I mean, I think every single piece of information on here, you have to know where it's coming from, right?
Sure.
Like you are tracking rates of pay somewhere, you're tracking gross and net pay. So even if you're writing down in a ledger separate from the check that you're writing, presumably someone is tracking this because they're paying taxes off of it, right?
Correct. Yeah, and I
So
think
now
that's,
you're just saying handwrite that in your ledger and on the check. Like that's what we're.
yeah, and I
asking
think it
people
also
to do.
speaks to, Roman numeral 6 and 7. If I'm handwriting those checks, to the chairman's point, I think there's an opportunity to tighten it up. Talking about the purpose of all deductions and the description of the information used. I think that's for our smallest employers, those that aren't using third parties. I think that becomes an issue.
Yeah, and it sounds like that's an area where tighter language, I suspect the sponsor would be fine with that. I'm just concerned about if we suggest that this is a burden because, and in some ways this might be getting into the next bill that we're going to hear, but presumably every employer is responsible for knowing exactly all of these things and having them written down somewhere. And so now we're just saying the employee has to have access to it as well. So unless there's something that's here that the employer is not already legally accountable to the state and the federal government for having, then it seems like it's just a matter of words of how we put them onto the pay stub, right? Okay, good. Then I'm feeling really hopeful for this bill. Excellent. Thank you. Thank you, Mr. Chair.
All right, seeing no further questions, thank you guys very much.
Thank you.
Thank you, sir.
Thanks.
All right, colleagues, moving on to our last and longest bill. House Bill 465, Delegate Boafo. If you have a panel, sir. Wait. And I apologize for not recognizing this earlier. My eyes aren't that good. We have a former colleague who was actually a former member of this body, I believe, before most of us were even here or delegates. So and she is now the state's attorney for Prince George County, Aisha Brayboy. So thank you for coming today and coming back to your old stomping ground with this bill. I'm sure we're going to hear a lot about. So if we could go ahead, Delegate Boafo.
Absolutely. Thank you, Mr. Chairman, Vice Chair Crosby, good friends on House Economic Matters Committee. For the record, Delegate Adrian Boafo here to present HB 465, Workplace Fraud and Prevailing Wage Violations. The misclassification of workers is a serious and very prevalent issue that happens far too often here in the state of Maryland. This practice deprives Maryland workers from earning proper wages. HB 465 moves Maryland forward by elevating the penalties for employers knowingly failing to properly classify employees. This bill protects Maryland workers and safeguards our state revenues that are lost because of misclassification. Let me be clear, HB 465 will not affect those socially responsible employers who are providing an economic pathway for many Maryland workers. Instead, this legislation is aimed at giving bad actors who knowingly have committed wage theft pause because of stricter penalties. For these reasons, Mr. Chair, Mr. Vice Chair, and colleagues on the committee, I urge a favorable report on HB 465.
Thank you very much. And thank you so much, Mr. Chair, Mr. Vice Chair, and members of the committee. For the record, I'm Aisha Brayboy, State's Attorney for Prince George's County and former member of the Economic Matters Committee. So this really, truly is a homecoming for me. And I do believe that this is the best committee here in the General Assembly. And you all are very fortunate to have your chairman, who's also my colleague and a former member of the State's Attorney's Office in Prince George's County. Did I kiss up enough? Okay. My office's Special Prosecutions Unit prosecutes, amongst other offenses, financial and economic crimes. We all too often hear complaints from workers suffering from the abuse of being improperly characterized as independent contractors rather than employees, or from the frustration of being paid less than the amount required by prevailing wage. In such cases, tools available to us are really lacking, and we really want to be able to address these cases more directly. The provisions proposed under House Bill 465 to criminalize these workplace abuses will empower my office, along with prosecutors' offices across the state, to respond more more effectively to this vulnerable population. Moreover, encouraging workplace fairness will not just benefit the aggrieved workers, but more importantly, will provide a competitive field for those employers who do not play fairly. For these reasons, amongst others, I strongly support House Bill 465. Thank you very much.
Hi, my name is Kenny Malik, and I'm representing Malik Mechanical Contractors. I earned my master plumber's license, started my open shop business at age 6. This October will mark 30 years in business. I served on the board of directors for ABC Metro Washington for 5 years. I had 180 hardworking, great employees 8 months ago. I now have 65 employees as I have been forced to close my contracting business due to unfair labor practices from open shop companies. Many of my competitors have adopted the illegal 1099 labor model where their people are not paid the proper wages and benefits as required by law. My legally operating business is 15% more expensive than these competitors that use the illegal labor practice, and I cannot compete against this without breaking the law. Many Maryland youth organizations will now lose out from the closure of my business, and we have supported many. Maryland taxpayers will lose out on the tax revenue from 125 employees and $50 million in revenue from the closure of my business. Maryland construction safety record is also not accurate, as these workers are not included in the OSHA 300 record books, as they are not considered as employees of firms. Maryland hospitals and taxpayers lose out by tending to these people in our local emergency rooms, considering that these people don't have health insurance or workman's compensation insurance. Construction worker fell to his death from the roof of a hotel that was being built in Baltimore. When OSHA investigated, 4 different open shop trades were working on the roof, yet no one of them claimed this person. This is unreal. Our system is flawed. Public health of Maryland is also in jeopardy. There are several diseases that are a direct result of non-compliant plumbing installations, such as Legionnaires, SARS, E. coli, to name a few. Plumbers are required to be trained and licensed in the craft, yet none of our local inspection agencies verify licensing on our job sites. Why? Please support House Bill 465 and Senate Bill 436 before other legally operating businesses go away. This bill is for the workers and our Maryland taxpayers.
Hello, committee. My name is Jason Williams. I'm here in support of House Bill 465. On the side of just hearing the gentleman testify of the workers that he lost, me being a returned citizen, this bill is something that adds another victim, and it adds to checks and balances that are needed to help people such as myself who pay taxes and dwell in this state as a returned citizen in a proper way and shape and form to contribute to my society. There is no victimless crime. There is opportunity for men like myself and those in our counties to find a way back to society that is true and proper by fair wages. When you have companies that steal, and that's what this is, they don't offer the proper service to those that work for them, and the services that can be provided for people such as myself, we lose as a state and as communities. So I support this bill because it affects so much more than we might know or see. I support this bill because it helps people like me get a better pathway. And because of that, and the opportunities provided by companies who do employ people such as myself in apprenticeships that I attend, which I'll be graduating in June, I'm able to give back to others, acquire knowledge through these apprenticeships, help others find a pathway better forward to achieve better goals in this state and throughout the country. So I'm in support of this bill, and if you have any questions, please ask.
All right, I'm shocked. So I'll go ahead and, I'm sorry, I was looking over to my right because my colleagues usually want to chomp at the bit, but so I do have a few questions to start. Delegate Boafo, what are the current enforcement mechanisms for wage theft?
Yeah, Mr. Chair, currently it's a $5,000 fine for each employee.
And who enforces that?
That's going to be the Department of Labor.
Is this bill trying to remove it from the purview of the Department of Labor?
No. It's
just saying in addition, and is there a private right of action for this?
I do not believe so, sir.
Okay, but because I guess I'm gonna move on in a minute, but everything that we're complaining about is already illegal. It can already be punished. It's just civilly. You're just trying to address that and now make it criminal.
Correct.
So, and I'm going to just say this once. I've been here 14 years and I've watched us almost every year weaken our criminal justice system. The people that carry guns and the people that do shoot and things of that nature, every year we seem to come out with any way we can to avoid jail time, to avoid a criminal record. Many times, even in this committee, they want people's criminal records to be overlooked. They want to make sure that if they commit a crime, they get a second chance at this. So I'm astounded that we're going to take such a hard left. I'm down with with punishing individuals. I'm down, especially with the civil infractions. We have turned so many former crimes into civil infractions, and now we're going to turn a civil infraction into a crime. And it's shocking, for one, because there's so many times when they come in here, I seem to be the only committee where people actually want individuals to be criminals. I'm the only committee where they come in and they say, well, these businessmen, we need to make sure that somebody gets a criminal record. I find that outstandingly shocking after all the years that I've been up here, that this is the hard left we're going to take with business owners, no matter how nefarious they are. So I'm going to be interested in hearing the rationale with this one thing, when everything else, we're making sure that nobody gets punished. We're making sure that nobody is held to a standard. But here, although there is a standard, and I'm going to ask other people about how many complaints in the enforcement mechanisms, because to see what's quote unquote broke. But I find it very disconcerting to see that this is the direction we're taking when we so many other times are terrified to give someone a criminal record for actual crimes, for assaults, for driving incidents. But now we want to criminalize something that we have an enforcement mechanism on. And we talk about poor young Black men getting an opportunity. Well, some of those are business owners. Some business owners look just like me. And so when we talk about enforcement and our quote unquote lack of faith in the criminal justice system, depending on how you look, I will put that right back. Well, then how do you think I as a business owner are going to get treated? And I again find it very shocking that this is the direction that we're going. And of course, I'm willing to listen. I'm trying to be open-minded, but I'm just taken aback because I've heard so much about the criminal justice system and how it treats individuals that look just like me. And I feel I have to remind you that there are business owners that also look just like me. And you're going to subject them to the same criminal justice system that you say we're not safe in. That's my comment. One last question. Is there a number that we're going to, as far as a financial amount that we would, that would have to be over before there was a prosecution?
I'm sorry, repeat that question, sir.
A number. Is it a single instance, a multitude of incidents?
It's per employee as written in the bill right now.
So per one person, one mistake, they can be prosecuted criminally.
Correct.
Okay.
And let me just comment on your initial thesis there. I won't comment on the current criminal justice structure because I don't believe that's in the purview of this committee. But this is what I'll say. There are thousands of Maryland workers, oftentimes low-wage workers, who are often affected by this. There are many laws in the books that we have that are both criminal and misdemeanors as well, that are meant to skirt bad actors. That's how our system works, making sure that those actors think twice before hurting the Maryland taxpayer. Additionally, if you look in law right now, if you were to perpetrate and misclassification on the state project, not only is it just a $5,000 fine, but against the state of Maryland, it's also 10 years punishable in prison as well. This bill is also just bringing that human parity in line with what the state's existing law is as well. Mr. Chairman, in addition to what you just said, you had made a prevalent point about the impacts of people of color in the criminal justice system. I wholeheartedly agree with you. However, Mr. Chairman, you're going to hear from people who look like you and I, who are both business owners and both on the employee side, who have both been run out of the state of Maryland because of these pervasive practices. What we have seen happen in California, in Illinois, in New Jersey, and in Pennsylvania is that when we move towards these enforcement models that are strict and give people second thought and pause, you see a reduction in misclassification. And I think folks in this committee will hear from those folks a little later on in those panels.
Doug Adams.
Thank you, Mr. Chair. And to the sponsor of the bill, good afternoon. And I want to just take a moment and kind of level set where you and I will have agreement on the subject matter, but also some very strong disagreement. You know, in 2013 or 2012, I sat in the chair where the Attorney General was sitting. And it was in defense of my family business who was attacked by Maryland's Department of Labor. You know, when I testified, the secretary and the commissioner and the administrators sat in the row right behind you and made fun of me as I was testifying to the committee about what happened to me. Well, what happened to me is that through the rebuttable presumption, which is the department's ability under Workplace Fraud Act to deem me in violation of the law and then grant me the courtesy of having to confront an administrative law judge and prove my innocence. I said that that's wrong on its foundation. What was further wrong is that the Department of Labor was wrong on their investigation. I was innocent of the charges of 56 counts of this Workplace Fraud Act. And when I showed up here, one of the things I said, and I probably should pull the video up to refresh my memory, but I remember it like it was yesterday. It was the hardest day of my life. The weight and the power of the Department of Labor was on my shoulders when I was trying to find my small family business in a place where I would exist after this exercise. And I got to tell you that my first blush at this is that I believe that cash being paid under the table is wrong, okay, is wrong. I believe that contractors who hire subcontractors for the purpose of cheating and undermining the legitimate forms of doing business in our state is wrong, right? And when I testified that day, I was testifying not for me and my business. What I ended up saying to Derek Davis, the chairman, is I said, I'm basically here testifying on behalf of these independent contractors who work for me in a legitimate fashion. And without a change in policy that we ended up getting in this committee before I became a delegate, we would not have been able to establish a working relationship with small independent business owners that frankly didn't go to college, don't have anything other than the weight of their heart to make a living, the power of their mind to use their hands to do a job. And so they do it not because they want to work for me or work for a union as an employee, but rather because they wanted to be a business owner. That was a persuasive argument in 2013. It remains a persuasive argument today. So where you and I have agreement is that under current law, with the power of one of the strongest regulatory departments in our state, with a commissioner that surely understands and knows how to use that power to affect change, that to say that at one point in time, maybe it's not me, maybe it's somebody else, will show up in this committee and say, I'm being charged criminally. I could end up in jail for 60 days per violation. You realize what that would have meant to somebody like me? 56 counts times 60 days. That's a year in jail for a labor law violation. It was actually incorrect from the lens of the department, who apologized. Okay, apologized and unwound the entire investigation. But it wasn't through the lens of we need to make a change for the sake of making a change. It's that there was a department that had the power and was willing to use it. And my question, now that I've level set where you and I have an agreement and some broad disagreement, is do you really think that the Department of Labor and the Commissioner of Labor and Industry needs the power to put people in jail in order to fulfill a regulatory requirement that this legislature has given them with prosecution and the ability to penalize and investigate as it exists today?
Thank you, Delegate Adams. Let me first say, I know you and I have had some conversation about this bill in particular. And while I agree with probably many folks in this room that your story is really harrowing and it's an inspiration story that brought you to Annapolis, we have a lot of agreement, and especially on the DOL enforcement side, right, which is a separate conversation outside of this particularly. Your question about prosecution kind of gets to the criminal justice issue holistically. I think, and this is why I introduced this bill, I think that what we need to do as a state is figure out how we can get stricter enforcement to ensure that not the good actors, you are the good actor, right? You are not the bad actor in this particular case. But there are very clearly some bad actors in Maryland who frankly are, not learning their lesson, right? And in that case, I do think that we have to ensure that we have stricter penalties. And this is that stricter penalty. More importantly, we've seen that stricter penalties have worked in other states, and we've seen that misclassification has gone down. I'm not a prosecutor, while there's one sitting next to me. I'll say this in particular. This bill says that you knowingly have had to misclassify a worker. I don't believe, and I'll let the state's attorney talk about this, I don't believe that there's a state's attorney here in the state of Maryland who's going to bring charges on somebody, especially a small business owner, without proving intent, which you and I both know that is extraordinarily hard to prove in the first place. These are those folks who are being pervasive in our community, are trying to underbid contracts and trying to ensure that they're putting money back in their pockets and not necessarily in the people of our state's pockets.
So thank you. And I just want to add, and Mr. Chairman, thank you for granting me some leash on the subject. The point of what I'm trying to share to you is that we're all citizen legislators who bring our life experiences, forward. If a bill like this was in existence in 2011, 2012, right? Just imagine what that would feel like when you knew that the department was wrong. The knowing violation part seems to be arbitrary in so much I still have to hire an attorney. I spent $30,000 of my money to defend myself against a false allegation against the department. Could you imagine what I would have to, the life I would have to live every night, waking up, figuring out whether I've got a business, but rather I'm going to go to jail. Am I going to be able to prove in a court of law that I did not have a knowing violation? I mean, those are the things that you and I as colleagues can have honest conversation on, and we should have conversation on, but it goes to the heart of what my concern is, which is you have the power. Look, under prevailing wage, you can debar a contractor from ever doing business again in the state of Maryland if there is a violation of prevailing wage. Workplace Fraud Act violations, repeat violations, yes, get to knowing violations, but literally every contract that I know I sign has in that contract the idea that I have to be in compliance with state labor laws. That's every contract that I engage in. And that if I'm in violation or have been found guilty of any of these state laws, that I cannot enter into that contract because the contractor will not allow. And I'm sure that the prime contract, especially on state work, says the exact same thing. Debarment is the end of the businesses. So I'm just going to close respectfully, Chairman. Thank you for the opportunity to have a respectful conversation with the sponsor. That you and I on the subject agree, we disagree in a very strong way about whether it's necessary to be talking about going to jail. Thank you, Mr. Chair.
If I could just respond, when we prosecute cases, it is our burden, not the burden of the business or the individual. It is our burden to prove beyond a reasonable doubt every single element of a crime, including in this type of crime, intent. So if an individual did not intend to violate or break the law, then there would be very little chance that a prosecutor, number one, would move forward on such a case, or number two, would be successful even if they chose to. The other thing is that this would be considered a misdemeanor offense. And as with most misdemeanor offenses, we look at ways to resolve those offenses prior to them going to trial. For the most part, compliance is the goal. It is not prosecution, it's compliance. Similar to how we handle traffic violations that are jailable traffic violations, similar to how we handle truancy issues, where we are not seeking to put someone in jail, we're seeking compliance because for the greater good. And similarly, that's how we would approach these types of claims because the individuals who have come to me, these are hardworking individuals who really feel that like they don't have a voice. And for many of these companies, the fine is just the cost of doing business, and they rather pay a fine if they're caught than to actually comply with the law. I think this brings everyone to the table and we can enforce compliance. Thank you.
Well, Madam State, thank you. I, as a defense attorney, disagree. I'll say that very clearly, that there are plenty of in fact, I've heard many people in this room testify to the dead opposite about when a state is left unchecked. And depending on the jurisdiction, the way these crimes will be enforced, who they'll be enforced upon. I've watched it, I've witnessed it, and I believe, as my good delegate said, there's nothing worse than that sort of Damocles over your head for 12, 6, 18 months while you await your turn in court. And while you're correct, the burden is obviously to the state. I will say again, this is no laughing matter. We have made such a big deal in this state about a criminal record, about giving someone, and we kept using that word. And remember, I was on the House floor saying, no, they earned it. But we said, no. It was given to them, some force that it changes their life. And we talk about not being able to get a job, not being able to get an apartment because you have a misdemeanor on your record. And then we also talked about the discretion and how terrifying of a word that was, because a certain jurisdiction, and I work in your jurisdiction, and you are very true. You're very true to your word. You're very magnanimous. I've seen it, but I also work in other jurisdictions, and that's not so much the case. And again, so I am terrified because other jurisdictions besides Prince George's will be enforcing this law. And I wonder what those people are going to look like. I'm curious. I'm sure, we'll keep discussing this, but I do understand, Madam State, your point of view, and you and I have talked because we're friends. And I understand your respect for the law. I understand the wonderful heart that you have, but you're not the only state's attorney in Maryland. So I thank you again for everything you're doing. I know what you believe, and I trust you, and I trust your word. You're just not the only state's attorney, but thank you.
Thank you, Mr. Chairman. Thank you for sponsor for bringing this bill to us so we can debate. This is the place for these types of conversations. I just want to get a little bit more background as we deliberate on this bill, because I too think that criminal penalty is a high bar. But you mentioned that there are states that do that, and maybe you have today at some point. Can you give me the states that do have this as a high bar? The other alternative, though, would be, is there some civil amount that others use that gets to a point? I think the chairman asked, is there some civil amount that could be a deterrent as well? I think that could be certainly another thing that might, get people to align. And the other is, revoking licenses and maybe never letting you have it again in that state. Is three sort of alternatives to getting to what you want. If you can provide me any information on that, would be helpful, I think.
Yeah, in terms of the current penalty system, I'm going to say that you're going to hear shortly from the Commissioner of Industry and Labor for the Maryland Department of Labor, who can probably tell you the stepped and tier system that we currently have, knowing that it starts at $5,000, but there's a lot of intricacies that go into that. So I'll defer to that. In regards to the states, yes, it's California, Colorado, Illinois, Minnesota, New Jersey, and Pennsylvania who are currently have mirroring legislation on law. 2, 3, 4, 6.
Thank you to your panel. Did you have another panel, or was this your only one?
No, got some more.
Okay, you can go. I'll let you from your desk call up your second panel.
Thank you.
You don't have to wave them up, but you can actually do it from your desk.
Cool.
I'm at the desk you're sitting at, so they can sit down.
Good afternoon, Mr. Chair, Mr. Vice Chair, members of the committee. For the record, my name is David Rodwin, and I'm the lead attorney of the Workplace Justice Project at the Public Justice Center. Pleasure to be with you here today to support this bill. I'd actually like to focus on another part of the bill that I actually think is more important than the criminal penalties, and that's the referral when there's been a showing by clear and convincing evidence that a worker has been misclassified under the Workplace Fraud Act, a referral to the comptroller. And why that's so important. It's not only important that our state receive all the tax revenue that it loses when employees are misclassified as independent contractors, it's really important for workers themselves. I've had clients who have gotten in tens of thousands of dollars of tax debt because of years and years of being misclassified as independent contractors. Home care workers, construction workers, janitors, these people are not their own businesses. They are employees like anyone is an employee. And when they're misclassified and they haven't, challenged it, it's a complicated process of challenging it under existing mechanisms, that they owe that self-employment tax as if they are their own businesses, which they're not. Referring these violations to the comptroller would, again, not only benefit the state, but it would benefit these workers by preventing them from getting in this crushing tax debt. A lot of low-wage workers who are misclassified do not even file taxes at all because they have already faced such a mounting pile of debt. So a really, really important part of this bill that we support. Another thing that is not in this bill language, but which would be great, is if workers could have an incentive. Right now, the $5,000 fine that employers face upon a violation is paid to the state. If a portion of that were directed to the employee, there would be an incentive for workers to bring these matters to the Department of Labor. So with that, we ask for a favorable report. Thank you.
Chair Wilson, Vice Chair Crosby, and committee members, I would like to first thank you for allowing me the opportunity to speak this afternoon. My name is Tom Gifford. I'm a business agent for Steam Fitters Local 602. Represents over 5,700 members in the DC metro area. Wage theft is becoming a business model in the construction industry in the state of Maryland. With the risk of being caught for wage theft being so low that it makes economic sense for employers to commit wage theft on a massive scale. In a study published by Yale University in 2018, employers steal more wages from workers each year than is stolen in bank robberies, convenience store robberies, gas station robberies, streets, and highway robberies combined. Wage theft is, by many accounts, one of the most common crimes committed in the United States. People most affected are women, minorities, and those without legal authorization to work in the United States. These companies thrive on these workers because these workers are less likely to have the time it takes to file a complaint and work their way through the complaint process. Most of the time, they're afraid of losing their jobs, becoming blacklisted, or being retaliated in other ways. A recent survey indicates there's an estimated $1 billion in estimated unreported Maryland wages, accounting to an estimated $100 million in annual Maryland revenue, specifically due to problems that this legislation addresses. Most of these are wage theft cases in the construction industry are from independent contractors who are paid less than minimum wage, no overtime, no benefits, not taxed, no workers' compensation, being deducted, no unemployment insurance, and should be classified as employees under the Maryland state law. House Bill 465 would require that all of these cases be referred to the state comptroller, so these backed actors must pay their share of taxes, unemployment insurance, and workers' compensation. The state of Maryland has become a safe harbor for these companies, and we are hopeful that House Bill 465 would deter these companies from stealing from their workers and the taxpayers of Maryland. I thank you again for allowing me the opportunity to speak today and ask for a favorable opinion for House Bill 465.
Buenas tardes, mi nombre es Milton Corado.
Good afternoon, my name is Milton Corado.
Residente del condado de Prince George.
I'm a resident of Prince George's County.
Esposo, padre.
I'm a father of two beautiful daughters.
Quiero compartir con ustedes mi viaje personal.
I want to share with you my personal story.
Uno marcado por el sueño americano.
One marked by the pursuit of the American dream.
Y las duras realidades del robo de salario que yo y muchas otras personas hemos enfrentado en Maryland.
And the harsh realities of wage theft that me and many others have faced in the state of Maryland.
Con el objetivo de crear una vida mejor para mi familia.
Trying to get a better life for my family.
Establecí mi propio negocio.
I started my own plumbing company.
Mis aspiraciones se enfrentaron a desafíos.
My aspiration faced challenges.
Ya que rápidamente me convertí en víctima de robo de salario.
As I
de
quickly
múltiples
became a
maneras.
victim of wage theft
De múltiples maneras.
in multiple ways.
Inicialmente conseguí un contrato informal con un contratista
I initially got a contract from a labor broker
que me atrajo con un pago inicial.
who started me with an initial payment.
Después de 3 meses encontré en una situación difícil.
After 3 months, I found
Sí.
myself in a difficult financial situation
Sin fondos para pagarle a mi equipo.
without funds to pay my staff.
Cuando solicité otro pago me informaron que no les habían pagado,
When I asked for another payment, they told me that they hadn't gotten paid,
dejándome en una situación financiera difícil.
leaving me in a difficult situation.
Mis trabajadores, en lugar de entender la situación,
My employees, instead of understanding my situation,
recurrieron a agredirme y amenazarme.
resorted in assaulting me and threatening me.
Decidí hacer la transición de propietario de un negocio a empleado,
Then I went back to transition from being an employer to an employee.
lo que no sabía que estaba entrando en una red de engaños,
I didn't know that I was getting to another web of lies.
prometiendo un cheque de pago cada 2 semanas,
They promised me that I would get a paycheck every 2 weeks,
pero retuvieron el primer pago,
and they hold the first check,
requiriéndome trabajar un mes completo sin compensación.
making me work for a whole month without getting paid.
Cuando llegó el día de pago me informaron que no les habían pagado.
When the payday arrived, they informed me that they didn't have the money and they didn't have gotten paid,
Y tuvieron que despedirme.
and then they laid me off.
Hasta el día de hoy sigo sin cobrar
Until this day, I haven't gotten paid,
y la persona que me contrató se niega a responder mis llamadas.
and the person who hired me, the labor broker, is not even answering my calls anymore.
Mi historia no es única.
My story is not unique.
Hay un sinnúmero de personas que enfrentan las consecuencias del robo de salario,
There is countless others facing consequences of wage theft,
por lo que estoy aquí hoy abogando por el apoyo del proyecto de ley HB 46.
which is why I'm here advocating in support of Bill HB 465,
Porque nadie debería tener que soportar lo que yo y muchos otros hemos experimentado en búsqueda de una vida mejor.
because no one should have to face what I and many others have experienced in our pursuit of a better life.
Gracias.
Thank you.
Chairman Wilson, thank you for this time. I'm going to run through this real fast. I know we're short on time. Chairman Wilson and committee members, thank you for this time. My name is Gerald Jackson. I'm the Assistant Business Manager of the Steam Fitters and Plumbers Local 486. I'm also the Secretary Treasurer for the Maryland State and DC AFL-CIO. I'm testifying in support of House Bill 465. In this climate of decriminalization, and I'm not a proponent of decriminalization, but that's where we are. Crimes against working families should not be considered as minor nuisances. We need to stop making excuses for businesses who deliberately cheat the state of Maryland out of taxes, unemployment insurance, workman's compensation insurance, and more importantly, cheat our hardworking men and women out of guaranteed wages and benefits. In Maryland, if you mistakenly cheat on your taxes, it's a crime punishable by harsh penalties. But if you're a business that deliberately cheats the state and its workers out of hard-earned wages, the problem is ignored. We have evidence that unscrupulous contractors in the construction industry have taken advantage of workers mainly from underserved communities, people of color, and or the immigrant workforce, who more often than not are unable or afraid to speak for themselves. These workers depend upon a state legal system to protect their right to be paid correctly. It's estimated that there's close to $60 million in wage theft in Maryland every year. Misclassification has become a business model in Maryland. Maryland's reputation as a state that doesn't protect its workers can and will attract rogue and unscrupulous businesses. House Bill 465 will be a deterrent and put the bad actors on notice that Maryland will no longer tolerate work fraud and misclassification of workers. In addition, House Bill 465 requires that these cases be referred to the state comptroller, certain states' attorneys, the U.S. Department of Justice, the U.S. Department of Labor, and U.S. Treasury. For these reasons, I'm asking for a favorable report. Thank you very much.
Good afternoon again. My name is Darwin Bonilla. I immigrated from El Salvador in 1998. After high school, I worked for 10 years as a community organizer at Casa de Maryland. In 2018, I graduated from the Steam Fitters Local 602 apprenticeship program and got my HVAC journeyman license from the state of Maryland. Later the same year, I became the lead organizer of the Mid-Atlantic Pie Trades Association. I lead a group of 9 organizers in the Mid-Atlantic area. Our job involves recruiting new members and bringing signatory contractors to our local unions. But one of the biggest challenges that we see every day is that many non-union workers, like Milton, some of them because of their immigration status, are being exploited by low-road contractors. These contractors hire labor brokers to provide the workforce that they need. In doing this, the labor brokers misclassify the workers as independent contractors and cheat them of their hard-earned wages. They're cheating the state also. In doing this, they also cheat in the state of Maryland out of workers' compensation, unemployment insurance, and also cheat in the federal government. We find these labor brokers on private sector jobs and state and local funded projects. Some of the prominent examples are William Wirt Middle School in Prince George's County, Eva Turner Elementary School in Charles County, Neillsville Middle School in Montgomery County, and Parcel 4 in Baltimore. HB 465 will help solve the wage theft and misclassification problem by creating meaningful criminal penalties for contractors who knowingly cheat and misclassify the workers. Wage theft and misclassification are rarely done by accident. For this reason, I ask for your support. Thank you.
Thank you. A brief question for the Spanish-speaking gentleman. What was his name?
¿Cuál es tu nombre?
Milton Corrado.
He spoke about his wage theft. Who did he report that to?
¿Ha reportado a alguien ese caso?
Sí, a ustedes.
So he came to us and we guide them to the Department of Labor.
And the Department of Labor couldn't do anything for him?
¿Sabes si el Departamento de Trabajo ha hecho algo por ti?
No.
I don't know.
You don't know?
No.
He said, so
No.
they could not.
¿Han hecho algo por ti?
No.
No.
And did they explain to him why they could not?
¿Les explicaste a ellos lo que había sucedido?
Sí, muchas llamadas,
Yes, I made many calls.
muchas personas.
And did they explain to him why they could not help him with his problem?
¿Te explicaron por qué no podían ayudarte con tu problema?
Sí.
Yes. ¿Qué te dijeron? What did they tell you?
Que tenía que reportarlo al departamento de labor y que ellos tenían que hablar con la constructora.
They said that I had to go again to the Department of Labor and they were going to talk to the general contractor.
And did that happen?
¿Sabes si eso sucedió?
No, no sucedió.
It didn't happen.
They just didn't talk, they stopped talking to him?
¿Dejaron de comunicarse contigo? Yes.
And how long ago was this?
¿Hace cuánto fue eso?
3 meses.
About 3 months.
3 months ago?
3 months ago.
3 meses me comuniqué con ustedes, ¿verdad?
He's asking me if 3 months ago he communicated with us, which is.
I mean, because we have the
the
representatives from the Department of Labor in here right now, and I hope that after this hearing that gets resolved
Okay.
as it should be.
So hay representantes del Departamento de Trabajo acá. Entonces, después de este hearing, él espera que ellos puedan hablar contigo.
And I would ask that you be in touch with me, one of you, about your results, especially if you feel you're being mistreated.
Él también quiere que tú te mantengas en comunicación con él para seguir el caso y asegurarse de que te resuelva.
So please wait for somebody to give you my card.
Por favor, espera para que alguien te dé la tarjeta de él.
Thank you. I believe that's it for this panel. Apologize. Miss anybody? Alex Charcuti.
I'm trying to, I appreciate the concern about criminalization and the conversation about the role of incarceration, but the comment that's been made a couple times is this idea that somehow the fine and the structure we have right now is the cost of doing business. And it's obviously hugely concerning. And I'm trying to figure out the math on some of this. I mean, Chris, you talked about that there's some numbers that you mentioned that are that the wage theft is more than bank robberies and all those kinds of things. I mean, I'd be interested in actually seeing those numbers, getting a sense of like what the data is that we have right now in the state, both from the perspective of how much workers are being stolen from, as well as if anyone knows the numbers of how much the state's being stolen from. Like, it's never okay to steal from the state, but when we're facing, like unemployment insurance, which, we're working on this bill and the trust fund is in trouble. And so the idea that while we're gonna have to address the taxable wage base because the trust fund is in trouble, there's a bunch of people who are stealing essentially from the unemployment trust fund, hugely concerning. When we're looking at budget deficits and there's money that's not going into our budget. And so we're struggling with how we're gonna cut this, that, and the other thing. And I'm just wondering if we have access to numbers, both how much is being stolen from workers, how much is being stolen from the state. And then I'm just trying to figure out the incentives. If $5,000 is the price to be able to steal $200,000, then that does seem like it's a pretty good deal. So I'm just looking at that incentive structure and that particular comment. I guess I'm making more of a comment, although there is data that I'm asking for. And if you don't have to give it to me now if you don't know it now, but I would like to see that data, because I think it's this question about cost of doing business and the impact to that kind of way of doing business, I think is a really important one for us to be talking about.
Delegate Charkoudian, there's a report from the Maryland Joint Enforcement Task Force on workplace fraud from 2019's annual report that estimates that over $1 billion unreported taxable wages, resulting in more than $100 million in unrealized taxes, are as a result of misclassification workplace fraud.
I can probably find that, but if you can send me that link, that would be
I'll send it to you right now.
helpful. Thank you.
Okay,
That was 2019.
2019.
And do you happen to know if we did anything with that report once it was completed?
I can't say that we had.
Yeah. Okay. Thank you, Mr. Chair.
Harrison, I'm sorry, I didn't hear you. Thank you so much. You mentioned some specific examples of the wage theft. You mentioned William Wirt in Riverdale, which I attended. And then you mentioned another school in Charles County. Can you just briefly go into detail what exactly happened, how you determined that there was wage theft?
Yes, so when we visit a job site, especially on prevailing wage, we usually pull the wage determinations, which has the what wages each craft should be paying. Then we go and talk to the workers. We ask them, are you a plumber, electrician? How many, how long you've been here? And then we ask them, how much are you getting paid? A lot of times they would give us the information, and then we ask them if they know that this is a prevailing wage job. Many times they don't know, especially if they are working for a labor broker. And they said they don't know. So then we pulled the certified payroll. So Eva Turner specifically, we did that. And all the workers performing the plumbing work were not being reported on the certified payroll. So they were lying on the certified payrolls. They were not paying the prevailing wages. And then the workers decided to file a lawsuit against the contractor, the labor broker, and the general contractor. They ended up settling for more than what they owed. That was 2 workers who came up and did that. There were 12 more workers who, for many reasons, some of them were afraid because of retaliation, didn't do anything. We went to some government agencies and told them, this is going on here. And up to this date, as far as I know, nothing has been done to those workers or to the contractor that did it. The same contractor is doing William work right now, doing the same thing, using another labor broker. The workers are being misclassified and not getting paid the prevailing wage.
All right, thank you so much.
So the cycle just continue repeating and they're just getting away.
Thank you so much.
Seeing no further questions. Thank you guys very much.
Thank you.
Bruce Briano. Commissioner Vick.
Good afternoon, Mr. Chairman, members of the committee. For the record, Bruce Periano. I'm here on behalf of the Alliance for Construction Excellence. And some of you that were with us last evening, thank you again for joining us. Good conversation and hopefully very constructive. We very much support the issue and the contents of this legislation. It's been a continuing issue and problem of misclassification of employees and dealing with violations. The bill is very strong. You've heard testimony. I don't want to repeat that, but the main thing is we really feel something needs to be done and addressed by this committee. It's an issue that has lingered for a long time in the legislature, respectfully, without putting arms around it and trying to resolve it. It does need vigorous enforcement by the Department of Labor. I believe the previous testimony referred to a document which I can send out to everyone here for those of you that are not aware, but this past last month, well, the end of this month, January, there was a report done on evaluation of worker classification protection unit done by this legislature. I have a copy, Mr. Chairman, members of the committee, of this report. It was recommendations that are made and some very valuable information that I think would be very helpful to this committee in their consideration of this issue and the recommendations that are made here. I know previous administrations have, through their Department of Labor, have adopted well, we're not going to go out looking. It's going to be complaint driven, and we're going to act on that. But recommend this report. I will send it to the committee members if that's okay with you, Mr. Chairman, so that everyone has it.
You don't have to do that. I believe we have it. I believe we can get a briefing about this. So
all right, fine, thank you. And I would recommend utilizing this as you consider this legislation. Thank you very much.
And Bruce, do you know when that report, when the recording of that took place, what years were measured?
Some 2014, 2015. I'm looking at some of the charts.
It's fair to say it is a different administration, and one would say a more conservative administration and a more conservative Department of Labor, correct?
Yes, and respectfully, and I'm just being objective. It was an administration that believed in complaint driven as opposed to going out and looking.
And so that's the problem with the report, is reflecting a different ideology as far as enforcement. So relying on that report for bills going forward is very difficult because we have an entirely new Department of Labor and a new outlook as the way they're going to enforce
right. And I think that's very relevant to this consideration, not only of the legislation, but what, if anything, the legislature is going to do on this. And I
thank you.
I think that is important. Thank you very much.
Go ahead, Commissioner.
Thank you, Mr. Chairman. I look forward to discussing that report with this committee on Tuesday during our briefing. With regard to HB 465, we recommend a favorable report with amendments. As has been said, HB 65 would strengthen, and we think in a targeted fashion, the enforcement tools that are available to combat wage theft on state-funded prevailing wage projects, as well as worker misclassification. Again, we do think that the bill is targeted only at knowing violations that is specific within the bill. And permitting criminal penalties signals the importance of these issues by strengthening the sanctions, and thereby assists with our compliance efforts under both of these laws. We do have one suggested amendment and one point of information. The suggested amendment is with regard to the referral process that is discussed in 3910B and 17227B as well. It contemplates a referral process by our division at the Labor and Industry to various authorities, including the Department of Justice and the Department of the Treasury. Those pathways don't currently exist between our agency, or at least my division, and those authorities. I would say that the Joint Enforcement Task Force on Workplace Fraud is designed to try to work with the Comptroller, the Attorney General, and others who might already have established pathways in that regard. So we would suggest amendment of that language to reflect the correct counterparts for the pathways for the referral process, rather than have it be from the Division of Labor and Industry. That's a technical amendment. The second point is really a point of information. Prevailing wage as currently written contemplates a knowing violation of the subtitle only under 17222A2, which is the underpayment provision. We would suggest potentially narrowing the criminal liability provisions in this bill to attack just that knowing violation, as opposed to any knowing violation of the prevailing wage statute. I'm happy to answer any questions. I apologize for going over.
You're fine. If there is anything else you had to add, it's a good time.
I would say in regards, I found the testimony from the prior panel very troubling. Certainly within the time frame of 3 months ago, that is when I was there. And I am committed, and I hope they have not left the hearing room. And I will be going over to speak with them to try to find out what happened and where the ball was dropped there.
And I believe my vice chair also provided them with pretty much every contact in Department of Labor to make sure that this did get handled.
Well, I'm right here, and I
know you
will.
are. I know you are, but you were busy. I knew you were preparing to testify, so we didn't want to distract you. But you're probably free to go now. I'm sorry, I do believe there's a question. Delegate Queen.
Chairman, my question is more for information for us to go through this later. I know I mentioned before asking about the fee structure, because I wanted to find out what that was. And hopefully you can get some of that to me, because we hear a testimony that seems like, you know, it's not enough to be a deterrent. So that would be a question I'd have. So getting that, understanding that. But the other part that should be a deterrent is revoking licensing. So do we have any history of where we even done that? Have we even used that anyway to deter these actions? So more information on that would be helpful.
I'm certainly happy to share what I know about both of those issues, Delegate Queen, and thank you for the question. With regard to licensure, there is no direct pathway under the law, because each of the licensing boards has their own requirements and laws, and there is no direct pathway for revoking licensure or corporate charter, for that matter, for a violation of these laws. There is, as someone mentioned, under some very limited circumstances, a possibility for debarment. But as far as I know, that has not been invoked in any case. With regard to the workplace fraud statute and the kind of civil enforcement scheme, here's what I can tell you. There is an initial citation, at least under the current version of the law. There's an initial citation that's issued. The employer has time to come into compliance, meaning make restitution and pay all of the relevant unemployment benefit contributions, et cetera, tax withholdings. And then they have a certain period of time in which to do that. If they do not do that, then a fine may be levied per employee of $1,000 payable per employee, payable to the general fund. The provision of the statute that speaks of knowing violations and the $5,000 per employee penalty. Again, that has a list of things that must be considered in determining the amount of the penalty, and one of those is violation history. So I think it is not contemplated under the statute that a knowing violation would be a first offense. I will say that as far as I know, and we'll discuss this perhaps more with the committee on during the briefing on Tuesday, I'm not aware of any knowing violation citations that have been issued recently, maybe ever, by the workplace fraud unit. So that's just a point of information for the committee.
Okay, one last question, and we may talk about this more on Tuesday. Another comment someone made about the impact to workers filing this, and it's a long process to go through. Any sense of what that time is? Because it seems like a criminal process is going to be a long process to go to too as well. So I'm not sure we're getting any benefit from that.
Yeah, I mean, I think a criminal sanction just proceeds on a different track. As the state's attorney described, they just have a different investigative process and a different set of rules by which they determine whether to prosecute and what the standards are for their prosecutions. In the civil context, our investigative process can, I think our aspiration is to get it done within 90 days. But the reality is that particularly on both prevailing wage projects as well as worker misclassification issues, these are fact-based issues, and they require, in order to have due process for all sides and make sure we have all of the information that we need, they do require some time. And that can be exacerbated by the difficulty of getting workers to actually come forward and cooperate, which was alluded to earlier. So I can't give you an exact timeline, but it's not, it may be shorter than a criminal process, but there is still delay that affects the individual who is due their wages that they have not been paid.
All right, thank you very much.
Madam Commissioner, in hearing you speak, I was curious. You said that there were no debarment that's not been used since you've been here, correct?
Certainly not since I've been here.
Okay. And we also spoke briefly about making sure the individual, you said you did not have a direct pathway to for civil enforcement to make sure that they can't, do business in Maryland.
That's correct. I don't believe that there is currently a system for either having even repeated violations of our prevailing wage laws or our labor standards laws affect your licensure or affect your corporate charter.
Right. So people continue to have these violations almost with no recompense. So do you think that would be a good idea, maybe to try to give you guys a little more authority? I guess I say that because you just said there were no, apologize for the word that was used, but the violations, none had reached the level of debarment. So wouldn't we be in the same scenario if we gave you that power in addition?
Well, debarment is ultimately, right, is a decision of the board of public works.
Okay.
It is a ground for debarment to have repeated violations of these laws. All I'm saying is that I don't believe that to the extent those have been reported to the Board of Public Works, I don't believe there has been a debarment proceeding on that basis. That's what I meant to say.
And is that would that be a useful tool in your toolbox? Not the debarment, obviously, but the dealing with
licensure. I think it would be. I think what we're hearing is that more tools and more kind of direct consequences that get at the ability to do business in the state using this business model that is very harmful to all of the state stakeholders. Anything that could get at that would be helpful.
And I say all that to say that obviously giving more tools is important when the current tools have been utilized. And so I guess there's concern that there is a lack of complaints, that there's not a lot of enforcement. And I don't want to put this squarely on your shoulders, but you understand the direction that conversation will go. And we can have a conversation offline, because this is a problem that we need to resolve. I think we keep trying to chip away at it. I just, I want to see what else you think you would be able to utilize to prevent this and provide long-term punishment for individuals who are repeatedly violent. Like you said, that we've heard multiple times becomes the cost of doing business. And maybe the cost of doing business is no longer being able to do business in the state.
Maybe. And I would thank you for that suggestion. I would welcome that conversation. I would say these are some of the things that the Joint Enforcement Task Force that was just created will be looking at, putting all of the tools on the table and trying to figure out how to deploy them to most effectively combat this business model for all of our stakeholders.
Thank you very much, ma'am.
Thank you.
I'm sorry, Chris. Sorry, buddy. But
Thank you, Mr. Chair. And I just want to be super quick on this because I want to just echo the things I was sharing to the bill sponsor. He's a colleague and a friend of mine. And I share that same sentiment and message to you, Commissioner, because, one of the things I'm hearing is that prior administrations and how they respond and act to these things are different than what you'll do and what you're doing. Let me just add to that, before there was the Hogan administration, there was the O'Malley administration and their application to the same subject matter, which was, let me just be blunt, was probably the exact opposite to what Al Hogan approached it. And those were the things that landed me in some real frustrating examples. So next Tuesday, when we have our briefing, it'll be better for us to have an administrative conversation. This bill I completely and utterly oppose on its principle, because I believe inherently that the tools and the power of your of you as the commissioner, I can see and feel as a private sector merit shop business owner. And I want to share that with you. Two questions. The first one is the joint.
That was the short version?
That was my.
Go ahead.
The Joint Task Force on the Workplace Fraud Act has been around for a very long time. I know Westmore did a executive order, but that's been around since O'Malley's administration. And the purpose of that was to coordinate with comptroller, with workers' compensation, unemployment insurance, and that was an annual report, right? So we're not just doing something brand new. But the question, and the reason why I ask you, is because within those prior year reports, the department was getting paid bonuses by the U.S. Department of Labor for violations. Like they would show the violations, and then in these reports, I would encourage you to take a look at that because that was one of the criticisms that we brought, was the idea that with enforcement comes the why. Is it complaint based, or are we doing these for other reasons? And I just share it with you. It's in writing. It's in the reports from 2010, 11, 12, and et cetera. And then to the question, which is that, you know, in this bill, it talks about wanting to refer to the comptroller. Well, that joint task force and workplace fraud act already allows for, encourages cross-department cooperation on the subject.
Yep. If I may respond, I think we agree with your second point, hence our suggestion as to an amendment on the referral pieces. And second, I would say gently that a complaint-based system of enforcement only is not going to really address the problem as a whole. And again, that's part of what I think the new task force is dedicated to trying to tackle, is how to do enforcement on a basis that will actually help to move the needle on compliance.
I actually don't disagree with that. The second question is the rebuttable presumption. So the state's attorney for Prince George's was talking about an effort, but under Workplace Fraud Act, there is the rebuttable presumption. There is the investigation with the rights for the employer to kind of prove the opposite and or change the burden, if you will. So that still exists, right? I mean, the administration, your department, can go after and investigate these sort of things, but it's through the lens of not proving the case, but rather you have an allegation and you're asking the employer to then say, well, look, I think you're wrong. So that's one of the main frustrations on a bill like this, because that sort of rebuttable presumption is that you're guilty unless you can prove yourself innocent, and can theoretically lead to, in a court of law, trying to prove a negative, which is exceedingly difficult, if not impossible. And then if that's the case, aren't you putting potential criminal penalties in front of somebody that from the start, from the basis, is a flawed legal premise?
I am not a criminal prosecutor, so I would defer to my sister at the bar on that issue. But I would say that I do think that as she testified, the criminal process and the burdens of proof in the criminal process are very different than in a civil process. And in the civil investigative process, you're obviously right that there is a rebuttable presumption of employee status if certain conditions are met under the law.
Yes.
But I would note that it is rebuttable. And once it is rebutted, and at any hearing, the department has the burden of proving all of the elements. So that is the state of the civil law as well. But you're correct that the law presumes employee status in these two industries that it covers if certain very specific characteristics are met.
Commissioner, thank you for your testimony.
Thank you.
All right, seeing no further questions. Thank you, Madam Commissioner. And I don't think anybody has experienced the Thunderdome in 2024 quite like you. So keep your chin up. Appreciate you coming in to ECM. You're doing
Absolutely.
great.
I'll be seeing you on Tuesday.
Oh, can't wait.
Thank
All
you.
right. We will now go to the virtual favorable. I have two. We'll start with Jonathan Bolden. Mr. Bolden, if you could turn on your camera. Okay, he's not here, and we will go to Mark Ulrich. You're not the governor's brother, are you? Former governor?
Hi,
All right.
can you hear me? Okay, good afternoon, Mr. Chair and members of the committee. My name is Mark Ehrlich. I'm a retired labor leader and currently serve as a fellow at the Harvard Law School Center for Labor and a Just Economy, and I'm here to testify in favor of House Bill 465. I've written 3 books, numerous articles and op-eds, many about the issues of misclassification, payroll fraud, wage theft, and the growth of the underground economy. The problems that this bill addresses exist across occupation and industries, but run rampant in construction. A 2023 study by the Century Foundation found that between 1.1 and 2.1 million construction workers are either misclassified or paid in cash off the books. The incentive is simple. It's labor cost savings. This illegal and unethical business model offers savings up to 30% and represents a huge advantage in a highly competitive industry. This is not a victimless crime. Workers who are misclassified are not protected by state and federal laws governing employment status, such as minimum wage, overtime, and anti-discrimination laws. Wage theft is common in this environment and occurs disproportionately among workers of color and immigrants. Law-abiding employers and their workforce are also victimized by this business model. Those employers who continue to fulfill their legal obligations to find themselves regularly underbid by those who cheat, resulting in lost opportunities and declining revenue. And even taxpayers are ultimately victimized. The Century Foundation estimates that taxpayers lose between $5 and $10 billion per year. This is not a silver bullet, but it will bring Maryland law more in line with a number of other states that have both civil and criminal penalties. Legitimate employers should not fear stronger penalties. In other states with similar laws, the problem remains limited resources rather than arbitrary enforcement. Stronger penalties also serve as a deterrent in order to achieve the ultimate goal, which is compliance with law. I strongly urge the committee to give a favorable report to this bill. Thank you.
Thank you, sir. Seeing no questions, that concludes the favorable witnesses. Now we'll turn to the opposition. And in the red corner, we have Grayson Wiggins, Mike O'Halloran, Kirk McCauley, and Tommy Thompson. You can start when ready.
And good afternoon, Mr. Chair. Thomas Thompson on behalf of the Associated Builders and Contractors, as well as the Maryland Minority Contractors in opposition to this bill. As a lawyer, I've learned that laws without enforced consequences are nothing more than suggestions. And that's what we're hearing about today, unenforced consequences. This law was drafted in 2009 by then Secretary Perez, one of the fiercest advocates for workers. He became the Labor Secretary of the United States. This law is not weak whatsoever. The Workplace Fraud Act has fines of $5,000 per employee on your first offense, $10,000 per employee on your second offense, $20,000 per employee on your third offense. The prevailing wage law is even more. And they both have private causes of action where attorney fees can be recovered. And you haven't sat on your hands. You've actually in 2019 beefed up this law by giving a private cause of action in the prevailing wage arena. That opens people up to class action lawsuits. In 2022, you added stop work orders where you can shut down work sites and related work sites to get the attention of those folks. And what did we hear the Department of Labor say today? We haven't used any of our tools. However, we would like another tool in the toolbox. Effectively use the tools you have, demonstrate that there is a problem, and then we can discuss criminalizing this type of behavior. There are ways to get to the end result you want. They shall file, the commissioner shall file a list of bad actors who repeatedly do this with the Secretary of State, and they are debarred from practicing in this state and bidding on contracts for 2 years. That's a death penalty for a business. Criminalization also exists under our tax laws. When you don't take the money out of people's paychecks that you're supposed to be withholding, that's a 10-year penalty. Again, this is a matter of enforcement, not of criminalization. We're taking a step backwards. We're not harmonizing folks who wholeheartedly agree on this issue. ABC and MMCA testified in support of this bill in 2009. We believe in the merits of the bill today. We don't believe anything more is needed. Thank you.
Oh, Chair Wilson or Vice Chair, I don't know if you transitioned to that when you get up there or not, but my name's Kurt McCauley. I'm WMDA car. We represent service stations, convenience stores, and automotive repair shops across the state. And I'm just going to say me too. With what Chairman Wilson said as far as taking a civil law and turning it into a criminal law, it just doesn't make sense. But I won't extend it. Tom said just about everything needs to be said. Right here in the law, it's $20,000 for the third offense. So I keep hearing these repeat offenders. Well, I don't know what they're applying, but the law is there to get them right now. And thank you for urging no vote on it.
Good afternoon, Mr. Vice Chair. Very quickly, Mike O'Halloran here today on behalf of NFIB in Maryland, a me too as well. And I just impress upon the points that not only the chair made, but Delegate Adam made as well. Respectfully to the state's attorney, you know, if I'm a small business owner and I have just merely the threat, you know, I appreciate what the state's attorney is saying that they, you know, once they get to court, they have to prove these things. There's a lot that happens before a small business owner ever gets to court. And it's frankly the threat. When I'm a small business owner and I have the government come and knocking on my door, particularly a prosecutor saying, hey, we're going to bring you to court unless you do X, Y, Z. You know, that's a pretty profound statement that this bill seeks to make. And I would, you know, instead I would defer to what's already in place, some very hefty fines. If those fines, according to the proponents, aren't getting it done, before we start talking about criminalizing and adding people to our criminal justice system, you know, I would say at least a baby step would be reassessing the amount of fines. That's not to say I'm advocating for that. I don't want that to be twisted. But I am saying, you know, to the point of criminalizing this behavior, I think that's a very, very heavy-handed approach. Thank you.
Good afternoon, Mr. Chair, members of the committee. Grayson Wiggins here on behalf of the Mid-Atlantic Flooring Association. I'm a bit me too to what has been said. I would just note too that my client is comprised of a lot of small contracting companies, mom and pop companies, and $20,000 penalties in the aggregate per employee are certainly not the cost of doing business for my clients. Those are hefty and significant penalties that are deterrents that are available to the Maryland Department of Labor. Additionally, you heard the commissioner mention the mitigating factors in the statute. We find it interesting that the bill as drafted specifically excludes the criminal penalties from the mitigating factors that are already in the statute. We have some concerns with that. There's been a lot of discussion about repeat offenders. Again, the criminal penalties in the bill are not attached to repeat offenders. As one proponent noted, one violation or mistake could put you in a courtroom staring across the room at a state's attorney in any county in the state. And that is exceedingly concerning for my client, which again is comprised primarily of small companies that work with subcontractors. Additionally, there is no language in the bill, no off-road that would require the department to work with good actors who are doing their best to comply with the law. And so we would encourage the subcommittee or the committee to look at including language in the bill in that regard as well. I'd be happy to answer any questions, Mr. Chair. Thank you.
All right, seeing no questions, that concludes this panel and the bill hearings for today. I want to thank everybody and see you tomorrow.